Good evening, everyone. My name is Andrew Robertson, and on behalf of the Obligations Group at Melbourne Law School, I'd like to welcome you to our first Obligations Group lecture of 2020. We've, for obvious reasons, made a rather late start to our lecture series for this year. And it is also our first Zoom lecture, our first Obligations Group lecture via Zoom. So I'd like to begin by acknowledging the Wurundjeri people of the Kulin Nation, the traditional owners of the land on which Melbourne Law School stands and on which I'm standing, and I pay my respects to their elders, past and present. So many of you are, of course, a very long way from Wurundjeri land, and I'm really delighted that you could all join us for tonight's lecture. There is, of course, a great benefit to meeting via Zoom rather than in person. So there are some significant drawbacks to living our professional lives online, as most of us are doing, but we're learning that there are also some distinct advantages. And I suspect that when this pandemic is behind us, we'll continue to hold at least some events in formats like this because of those advantages, because we can get together across such great distances. So I'd ask you to keep your video and your microphone switched off during the lecture. And if you'd like to ask a question at the end of the lecture, you can use the raise hand function in Zoom at any time, and I'll take note of your name. You can also tell me in the Zoom chat if you'd like to ask a question, or if you prefer, you can just type your question into the Zoom chat and I'll read it. I also need to let you know that this Zoom session is being recorded. Tonight's lecturers will be very well known to most of you. Elise Bant is Professor of Private Law and Commercial Regulation at the University of Western Australia. She's also, I'm pleased to say, a Professorial Fellow of Melbourne Law School. And she has recently been awarded a future fellowship by the Australian Research Council for a project in which she'll examine corporate liability for serious civil misconduct. Jeannie Paterson is a Professor of Law at Melbourne Law School and co-director of the University of Melbourne's Centre for Artificial Intelligence and Digital Ethics. For a number of years, Elise and Jeannie have been working on a project on misleading conduct and related doctrines, which has been funded by 2 Australian Research Council grants. Last year, Elise and Jeannie hosted an exceptionally good workshop at Melbourne Law School examining misleading silence across a range of common law and equitable doctrines and statutory regimes. And in their lecture tonight, Elise and Jeannie will share their insights from that misleading silence project. So I'll now invite Elise and Jeannie to present their lecture.
Thank you very much, Andrew. I hope everyone can hear me clearly. I'll do my best to be as clear and distinct as I can. Firstly, it's my privilege and pleasure to present this talk to you from the lands of the Whadjuk people, of the Noongar people, and I would like to pay my respects to their elders, past, present, and emerging. So, to start us off, I need to introduce our project itself. Our project itself is concerning the law of misleading conduct, one of our foundational legal norms as first identified and explored deeply by Justice Finn, Professor Finn as he then was. And Justice Finn rightly recognised that misleading conduct is a foundational legal norm because it undermines markets, it undermines individual autonomy by vitiating the basis on which people enter into transactions, vitiating their decision making and undermining their choices. And as we also discovered during the course of this project, it also undermines relationships that are important to society. For example, when you have long-term relational contracts, misleading conduct can deeply undermine not only relationships that are important as a matter of economic advantage, but also are important from personal and social aspects as well. In light of that, it's unsurprising that Section 18 of the ACL and before that the Trade Practices Act contains a very powerful and broad-ranging prohibition on misleading or deceptive conduct or conduct that is likely to mislead or deceive in trade or commerce. That, of course, sits alongside a whole range of other areas of the law also concerned with misleading conduct. For example, intellectual property statutes dealing with copyright and trademarks, and broader common law and equitable doctrines such as deceit, negligent misstatement, passing off, defamation, injurious falsehood, common law and equitable estoppels, fraud, fraudulent and innocent misrepresentation, fiduciary obligations. All of these areas have something to say about misleading conduct. They try and prevent it, they try and respond to it, they try to ameliorate the outcome or consequences of misleading conduct. So it's unsurprising that in that context, this becomes a very complex and sometimes less efficient than desirable picture. Indeed, just simply in relation to the multiple versions of the primary statutory prohibition on misleading conduct, that is, the prohibition on misleading conduct in trade or commerce, that core prohibition has been replicated in various different forms across a whole swathe of different statutes at both Commonwealth and state and territory levels, with the consequence, because they're all framed in slightly different terms and to different effect, that they've created what one judge has described as a porridge or a labyrinth of legislation. So the question is, in that light, how do all these parts of the law fit in, and then what can we do about what seems to be an increasing level of incoherence? Well, this is where Jeannie and my project comes in. Our aim is to develop a rational law of misleading conduct by seeking to map the existing patchwork of rules and principles to promote more coherent legal development. This is not through trying to develop some sort of uber-tort of misleading conduct, but rather to understand the different ways in which the law seeks to regulate misleading conduct in all of its forms, and to try and promote more coherent legal development and reform of those different forms of regulation. Our starting point for this inquiry in the collection that we have developed is silence, which some might think is a surprising starting point, but as Jeannie will explain, actually has been a very useful starting point for this inquiry. She will first deal with the themes and doctrinal insights which have been developed as a result of the colloquium on misleading silence, which has led to the collection of essays, the picture of which you can see on your screens, hopefully. I will then take over to discuss the emerging taxonomy, which we have started to be able to develop in light of that work. So I will hand over to Jeannie at this point, who will endeavour to share her screen, and hopefully you will hear from me again shortly thereafter. Over to you, Jeannie.
Thanks, Elise. I think you might need to end screen sharing first.
Indeed.
Thanks. Thank you. Okay, and so I'm going to talk about some of the themes that have come out of the project, as Elise has mentioned. And the first question I'll address is, why misleading silence? And indeed, many of you have asked us this question with various degrees of forcefulness. Might seem strange, given our project is on misleading conduct, to focus on an apparent outlier, the nature of misleading silence and the appropriate legal responses to such silence. And it might be questioned, and indeed it has been questioned, whether this category really can bear any valid intellectual weight or shine any useful light on the nature of misleading conduct and doctrines informed by concerns about misleading behaviour. A fundamental question is whether silence can of itself mislead, or whether we're really talking about some other kind of conduct. about whether it's normatively justifiable to ask people to act positively to correct a misimpression that they themselves have not created overtly through words. Perhaps we're actually talking, when we speak about misleading silence, about other doctrinal categories, such as perhaps unilateral mistake or even unconscionable conduct, both of which were dealt with in the collection. And so it might have been safer and less robust for Elise and I to focus on a different topic. However, we found this one endlessly fascinating and found, I think as Elise has noted, it provides a useful lens for investigating a range of doctrines that are related to that core prohibition on misrepresentation, or in Australia, misleading conduct. It's an analytical tool that can investigate the relationship between the different doctrines. And as Elise has mentioned, we try to do this in the collection with papers on good faith, insurance, unjust enrichment, deceit, mistake, estoppel, accessorial liability, corporate disclosure, insider trading, and indeed class actions. So the breadth is quite extraordinary. And we found that the investigation by ourselves and by the contributors to this work have brought into sharp light the often formalistic boundaries between the different traditional doctrines that we're looking at, and invites a more nuanced development of themes across those categories. Some of the themes we have identified in the course of looking at these different doctrines and fields of law and the way they address misleading silence or failure to speak are questions about the normative salience of silence, the role of community expectations and relationships, the role of context in interpreting utterances, decision causation, and the significance of knowledge in allocating liability or making decisions about culpability. Something I'd add that Elise and I have been endlessly fascinated in, and you might want to watch this space, I think, to hear a little bit more. Now, I'm going to speak now about not all of those themes, probably you'll be relieved to hear, or will be here all night, but just on those first three, so the normative salience of silence, or perhaps actually more accurately, the ethical and moral dilemmas raised by trying to attribute liability to merely saying silent, the role of community expectations and relationships in allocating liability for remaining silent, and the importance of context in interpreting utterances. And what I'm going to say comes out of the work that Elise and I have done, but also to some extent the work of, well, a large extent, the work of the contributors to the collection. I would not dream of speaking for them, but I will at times allude to their work. So first of all, the ethical and moral dilemmas raised by thinking about silence. Probably to a large extent, the genesis of the book lay in the work by Tony Duggan, Michael Bryan and Francis Hanks, Contractual Non-Disclosure, which is published in 1994. And this book explored issues of disclosure from perspectives of individualism, fairness, and the insights of law and economics. And in so doing, it highlighted for Elise and myself, and I think subsequently participants at our colloquium, the extent to which decisions about when silence is misleading or broadly culpable are grounded in normative judgments. So we're looking at drawing lines in the sand, so to speak, about the balance that has to be reached between standards of interpersonal fairness, self-responsibility and efficiency. And these aren't easy questions, because obviously those different normative standards are speaking in different places and to different things. Michael's chapter in the book reminds us that such debates have a very long history. So Michael's chapter points at, like contractual non-disclosure itself, to Cicero's commentaries about the arrival of a grain ship in a time of famine. Now, the one ship is ahead of the others, and the question that's to be asked is, can the owner of the grain on the first ship that arrives demand an extortionate price for the sale of the grain when he knows perfectly well that there's several other ships just a day behind? Is there a moral or legal obligation to disclose the fact that those ships are coming? A similar question relates to the scenario of a termite-infested house, again to explore the responsibilities of a seller, this time in relation to intrinsic defects as opposed to external considerations. is the seller of the house infected by termites morally or ethically obliged to disclose that factor? Now, as the property lawyers amongst us will know, that remains a pertinent discussion, and indeed we're constantly coming up with other similar questions about when disclosure is required about implicit defects. So there's been quite a lot of debate in the last couple of years about what happens when a house is sold, where a murder or other violent act has taken place. Is there an obligation to disclose that on the ground that purchasers of the property would actually want to know that information? Now, Cicero actually didn't have an answer to those questions, and you can go and read either Michael's book, Michael's chapter, to find out a little bit more about it. But what the discussion helps us do is perhaps pull out with a little bit more nuance the varying competing considerations about that we may have when we're thinking about when silence is misleading, and conversely when disclosure or a duty to speak up should be required. Now here, I think law and economics is helpful, but so are the other values. So for example, market efficiency does favour preventing mistakes. If people make mistakes, particularly pricing mistakes, there can be distortions of the market. But considerations of market efficiency also require us to think about maintaining incentives to discovering useful information. So if there's a requirement to disclose all information that's been obtained by a seller, for example, in the grain SIP situation, or we may lose incentives to be innovative and try and do new things. Equally, the ethical imperatives are not so clear cut. So you might argue it's fair and respectful to the other party when you're negotiating for a contract or transaction to disclose pertinent information that one party's aware, the other party doesn't know about. But that's generally, as you all know, not the approach taken in our law. Our law, private law, generally sees nothing offensive in taking advantage of a position of superior information in the absence of other factors that may demand disclosure. And from a moral perspective or an ethical perspective, this is entirely consistent with a liberal philosophy which expects and indeed demands an element of self-responsibility. If we're going to play in the market, we have to take responsibility for ourselves, for our own outcomes. So one of the interesting themes I think that's come out of this work is how these different imperatives play out in different situations through different doctrines. So the imperative of encouraging self-responsibility changes and is indeed replaced by an ethic of care. And we see this in the work of Middich and Wishart in particular, and also Rick Bigwood. This ethic of care may arise when one party is visibly disabled from making decisions about his or her own best interests, and then the party with superior information perhaps cannot stand by and exploit the asymmetry of information that exists in that particular relationship. So that brings us then to the second key influence on this collection, or this book, which is the work, of course, of Paul Finn that was mentioned earlier by Elise. So Finn's, in particular, Finn's article, Commerce, the Common Law and Morality, drew attention, particularly in Australian law, and particularly with the influence of the Trade Practices Act and that overarching prohibition on misleading conduct, to doctrines and principles that are premised not only on a neoliberal philosophy of robust self-interest and equally self-responsibility, but may require more neighbourhood or neighbourly responsibilities, even in situations outside that classic example of, unconscionable dealing, where one party's dealing with someone who's under a visible disability. And that these neighbouring responsibilities, these wider neighbouring responsibilities that are nuanced to the nature of the relationship, can nonetheless in certain situations impose a duty, and I think we can put it that strongly, a duty to speak up for the benefit of the other. So for Paul Finn, the idea of neighbourhood is the idea of a positive and not merely negative responsibility. It's not merely waiting for one party to be aware of a disabling condition on the part of the other. In some circumstances, the very nature of the transaction will demand positive responsibility to speak up or step up. To these norms, and we can see these ideas played out, these different ideas of responsibility played out through concepts and standards we're very familiar with in Australia, beyond, unconscionability, good faith and fair dealing, and fiduciary duties, all of which impose various duties that arise out of the nature or the proximity, I guess, of the relationship. To these, Elise has developed a norm against unjust enrichment. Central concern is to unwind transactions brought about by mistakes, but may, and also in certain circumstances, make failing to speak misleading, or at least impose that moral responsibility to speak. Another goal may be protecting reasonable expectations which arise from the conduct of the other party to a transaction and include an expectation of consistency. And Andrew Robertson's chapter, which I won't attempt to summarise, but I'll convene to you, talks a lot about these ideas in the context of the doctrine of estoppel. So these ideas are also played out in my pet topic, which is the doctrine of good faith and its relationship with disclosure. And its relationship indeed with misleading conduct under statute. So it's fair to say that if we're looking at the prohibition on misleading conduct in pre-contractual relationships, Australian courts, whether they're coming at as a negligent misrepresentation or the statutory prohibition, have shown a fair degree of scepticism about the requirement for one party to disclose information to the other. And that ties in with those ideas I've mentioned earlier, that disclosure is inconsistent with the idea of the competitive economy, the value of self-interest, and the demand for self-responsibility. Now that can change if there's other circumstances that make conduct misleading, such as to create a reasonable expectation of disclosure, which I won't say more about now. But those principles, that scepticism about obligations of disclosure when parties are negotiating, those ideas that we want parties to seek out and bring valuable information to the relationship and to be able to benefit from that, don't necessarily apply once the parties are in a contractual relationship. And it's here that the duty of good faith may have something to say. Once parties in a relationship, they come under, they're related in a contractual relationship, the nature of the duties that they're subject to do change. The incentives for benefiting from individually from information that becomes pertinent become less acceptable because the parties have come together essentially in a shared endeavour. Once parties have made a contract, each party is to varying degrees relying on the conduct of the other for the success of the venture. And the idea here is that there are obligations that arise out of the parties' shared expectations of performance, often expressed as good faith or loyalty to the contract, which fundamentally carries elements that are perhaps less controversial than the idea of good faith, elements of honesty, fidelity, and cooperation. The law of contract has long recognised a duty to cooperate in bringing about contractual goals. And it's possible that in some cases that this duty to cooperate carries with it a duty not to remain silent, a duty to speak up when staying silent would undermine the nature of that cooperative ethic at the heart of the relationship. So that would mean that in some circumstances there may be pertinent obligations not to stay silent, but to disclose information relevant to performance. This might be information about employment benefits that would not otherwise be known to an employee, the timing of performance obligations to allow for preparations to take place in an appropriate manner, and even the possibility of correcting a mistake about the nature, existence, or opportunities to exercise beneficial contractual rights. That brings me to my third theme. Issues around good faith disclosure, or when silence is misleading, raise issues not just about the normative influences on the law, but also squarely doctrinal questions. And the one that comes up that I want to speak about is this issue of pure or mere silence. We see again and again courts talk about the idea that silence may have meaning when it is combined with conduct or when itself has an element of conduct, but that in many contexts the idea of pure or mere silence has no normative or legal significance. It's an example of where there is no obligation to act to help another person. And that issue is squarely raised by Section 2.2 of the Australian Consumer Law when talking about when a party can be liable for misleading conduct. Draws an odd distinction, I think, between silence, which is part of conduct, and mere silence. In the case of mere silence, for it to be misleading, the silence must be deliberate. Now, this distinction between silence that's mere silence and silence that's conduct is actually quite difficult to apply. There are, of course, cases where silence is purely incidental, that it really doesn't perform much of a role, other than clarifying, I guess, an act that is self-misleading. So a good example is winding back an odometer when selling a second-hand car. I'm not sure if you can do that now because cars are all electronic, but once upon a time you could wind back the odometer and make the car look like it hadn't travelled very far. Now, that conduct is misleading, and the failure to disclose that that the seller has wound back the odometer really has little effect in that context. It's the silence that speaks for itself. Now, sometimes courts have spoken about implied representations in those sorts of cases, but I think that's really a sleight of hand, as Elise has put it elsewhere, to cover up the fact that the courts are looking beyond a representation, actually, to looking at conduct that's problematic. Elsewhere, I don't think that the distinction is particularly useful. In the Harding's chapter, and this brings me to the Harding's chapter, which is Matthew Harding and brother, speaking about the insights that linguistics can bring to our understanding of the meanings that silence has in legal relationships and the circumstances when it may be misleading. And part of that conversation is that language is always interpreted in a context. It can never be taken out of context. Therefore, the job at looking at silence is to investigate not just other behaviour that accompanies the silence, but the conventions, the context, the framework in which that silence takes place. And it may be that in some circumstances, it's that context that gives rise to, that creates the silence as misleading. It's not that the silence is mere silence or pure silence, it's simply that the context in which it occurs makes it problematic. One party can't be culpable for failing to be sufficiently sensitive to the understanding or misunderstandings of the other. They can't see into their mind. But in some context, the error or needs of the other party to the contract will or should be obvious. And in that circumstances, saying nothing or not clarifying the situation may well be misleading. And it's at this point we start to move, we can see that the obligations that attach to being alive to the context and the expectations of the other party to the contract may be graded across different kinds of relationships. And that's, I think, where Elise is going to take over. Is that right, Elise?
Yep.
Great. So I'm going to turn I'll turn my screen off.
Okay. Right, hopefully you can now see my slides back up. So I was talking before about the development of an outline of a taxonomy of the way in which the law regulates misleading conduct. And here we're thinking about the law comprising the rules of common law, equity and statute, because our aim is to try and think about the ways in which these different forms of regulation interact and the ways in which they may operate to support each other or conversely contradict or undermine each other. So what we find when we're thinking about a taxonomy of misleading conduct is that a norm against misleading conduct sits alongside a range of other very powerful norms and values. Interestingly, when we were developing this taxonomy, I kept on thinking about Commissioner Haynes' 6 leading principles or foundational principles that he articulated in the Royal Commission final report that he said underpinned pretty much all of our copious finance, banking and finance statutory regimes. they could be all boiled down to 6. And interestingly, you can kind of map his 6 principles with our 6 norms. Misleading conduct I have up at the top. That's not simply because this is about misleading conduct, this project, but also because we think that misleading conduct tends to be a very powerful, a singularly powerful norm perhaps. When we think about misleading conduct, one of the striking things about it is the law is concerned about the consequences of misleading conduct for plaintiff autonomy and for markets and so on, notwithstanding, for example, that the defendant's intention may be pure or may be reasonable or may be without the sort of levels of fault or culpability that we would normally require in order to give rise to some sort of legal liability. Misleading conduct is particularly concerned with prescribing a form of conduct which is innately problematic. And we could contrast that with, for example, the equitable doctrine of unconscionability, which it frequently overlaps. Often, unconscionability cases at the heart of them have some sort of impairment of the plaintiff's judgment, which has been brought about because of misleading conduct. That is, there's some sort of error which has been induced at during the course of the transaction between plaintiff and defendant, and the defendant then seeks to exploit that special disadvantage. Now, it's not always the case, of course, that the equitable doctrine of unconscionability will be engaged by misleading conduct, but it does seem that misleading conduct has a lot to say in relation to quite a few of the ways in which neighbouring norms operate. So there it is up the top, taking prime position. We have it next to neighbourhood norms, and here we might think that there are intersections, for example, with negligent misstatement, where there is a deep concern with misleading conduct, as well as with the neighbourhood norm itself. Unconscionability, I've already briefly spoken about. I'll come back to unconscionability because one of the things that we've discovered is that these norms operate at higher and lower levels of generality, and so we need to think about that as part of our understanding of the way in which these different forms of law interact. Good faith, Jeannie has already touched on. Again, there are intersections between good faith and misleading conduct. Indeed, prior to entry into a contract, for example, much of the work of a good faith principle is done by a prohibition against misleading conduct. Whereas once performance commences, as Jeannie mentioned before and as she discusses in her terrific chapter, the idea of good faith can be unpacked into ideas of honesty and cooperation. Certainly in the case of honesty, misleading conduct has a lot to say about what it means to be honest, but also in cooperation there can be ideas of needing to share information, disclose information, not engage in misleading conduct in order to see the contract through to fruition. Fiduciary norms also intersect in this area and with other areas of the law. Obviously, with fiduciary norms, we have circumstances where, for example, a fiduciary might need to disclose a conflict of interest to obtain consent from their principal. Misleading conduct seems to be engaged in that context. Again, one of the things we've discovered, though, is that while there might be intersections here, nonetheless, plenty of work remains for the fiduciary norm in a discrete way. And finally, unjust enrichment. As is well known, many cases of misleading conduct on the part of a defendant are a mistake from the perspective of the plaintiff. It's almost impossible to distinguish their operation except from the perspective that is taken. The difference here, though, is that unjust enrichment, of course, does not require proof of wrongdoing on the part of the defendant to give rise to liability. It is concerned with vitiated consent with want of autonomy on the part of the plaintiff. So to that extent is a particularly interesting body of law from the perspective of the broader norm of misleading conduct. Now, that is a quite complex picture already, and probably your brains are busy ticking over thinking about all of the different ways in which the different norms interact in your own experience and practices. But when we think a bit more closely, we can see that on top of this complexity are the ways in which the norms can operate both ex ante and ex post, as opposed to and also operate across time at different levels of generality and to different ends. So just to give you some examples, we all know that the statutory prohibition on misleading conduct operates to prohibit conduct that is likely to mislead or deceive. It doesn't actually need to be shown to have misled anyone, because engaging in conduct which is likely to mislead is inherently problematic, and that's enough to trigger the regulator's jurisdiction. As opposed to that, in most cases of private law, for example, deceit, and even in mistaken unjust enrichment, the law has an ex post operation. It's concerned with circumstances where the plaintiff's consent has been vitiated through misleading conduct, or in the case of unjust enrichment, is being mistaken potentially because of misleading conduct. In those circumstances, the law is concerned to remedy ex post the consequences of misleading conduct. And so we commonly see, for example, rescission and restitution being remedies in this space. Interestingly, though, there are still some areas where the general law can operate in ex ante fashion. So we were talking during the colloquium about the relationship between estoppel, mistake and misleading conduct. And for example, just thinking about estoppels by convention, they operate to prevent a person from resulting from an assumed shared state of affairs that have formed the foundation of a party's conduct, shared conduct. Sitting right alongside estoppel by convention is the unjust enrichment doctrine of total failure of consideration. And if you think about it, total failure of consideration is the circumstances in which the shared assumption, which is trying to be protected through estoppel by convention, where that shared assumption has already failed, where it has been resolved from, and then unjust enrichment steps in an ex post way. So it's there are very interesting connections between these different doctrines, potentially suggesting that there are, foundational concerns with autonomy and protection of decision making that are the particular concerns of these doctrines. Temporality of operation, again, just a little example, again, coming from Jeannie's area of good faith, is that, when one's entering into a contract, the obligation of good faith pre-contract is really largely dealt with through the prohibition on misleading conduct. However, once we become invested in performance, suddenly ideas of honesty and cooperation become paramount, and that these might extend beyond a mere concern with misleading conduct. Norms often operate also at different levels of generality. So here we can take as an example unconscionability. So unconscionability operates as an equitable doctrine that's specifically concerned with circumstances where there has been exploitation of a person's position of special disadvantage. That's the discrete equitable doctrine. But at a much higher level of generality, we can see it operating, for example, under statute under sections 21 and 22 of the ACL as a statutory norm or a statutory standard. And at a high level, again, we can see it operating in cases like unjust enrichment and in estoppel as a conclusion which is reached after having applied the more specific features of the particular doctrine in play. So, for example, in estoppels, there are all sorts of different varieties, estoppels by representation. If you have, or estoppels by reliance-based estoppels, I would call them. If you have an assumption which has been induced by the defendant in circumstances where the plaintiff has reasonably relied on that assumption to her detriment, then it becomes unconscionable for the defendant to resile from that assumption, because to do so would undermine retroactively the plaintiff's decision making. So we can see there that unconscionability is coming in as a statement of conclusion to give, really strong force to the sentiment that, there cannot be a change of position on the part of the defendant in that case. Now I'm going to stop there on this slide just a bit, because I do want to leave time for comments, and I have one more to go. But I just note that these norms are very rich. They have bilateral, communal and instrumental value in protecting valuable relationships, in correcting circumstances in justice between plaintiff and defendant, but also obviously in promoting valuable community outcomes. The final point I'd like to make before we conclude is just that a very interesting realisation that came out of our investigation of misleading silence and through it misleading conduct is the way in which duties to disclose cut across all norms. That is, duties to disclose perform a number of different functions, and when designing those disclosure obligations, it's critically important to have in view what kind of good or outcome you're trying to achieve. We did discuss in the colloquium, and I'm sure you've all experienced it in practice, the invidious practice of data dumping, that is disclosing a huge amount of information which can operate to mislead as much as it reveals. Certainly may not promote a more fully rounded consent on the part of parties to whom this information is disclosed, and may actually undermine the purposes for which disclosure rules are made. But even moving aside from that sort of data dumping, the different roles of disclosure rules are quite manifestly aiming at different types of outcomes. So, for example, if you have a disclosure rule which is designed to cure information disparity to level the playing field in the market, what will be required for that purpose will be quite different than what's required to cure or to cure a fiduciary breach through the idea of fully formed consent. Disclosure rules often operate as a proxy for example, informed consent. We say, oh, well, if you've disclosed, that's good enough. But we should never lose sight of the fact that disclosure rules are aiming at different ends and have to be assessed in light of the ends that they're seeking to achieve. Disclosure may not be a good of itself. It is only as good as the extent to which it achieves its designed ends. So finally, some conclusions. Well, the core statutory prohibition on misleading conduct undoubtedly constitutes an outstandingly pure and powerful iteration of the overarching norm. In a lot of cases, common law doctrines are much more, or general law doctrines, are much more rich and multifaceted. So, for example, we might say that deceit as a common law tort is particularly concerned with misleading conduct, But one of the things we discovered in the context of our inquiries was that deceit could also be understood in terms of obligations of good faith in certain contexts. So it's obviously simplistic to simply think of deceit in terms of misleading conduct. Likewise, many doctrines that we dealt with when we were looking at the doctrinal element of this inquiry have a concern to determine what the defendant knew at the time he or she was engaging in the misleading conduct. Now, that requirement of defendant knowledge is not present with the statutory prohibition, and we have seen needn't necessarily be part of the aim of that overarching norm. But in other contexts where the concern of the law is, for example, with very strongly relational norms, for example, the unconscionable conduct, for example, defendant knowledge might be critical. Defendant knowledge also sometimes operates, we think, as a defensive device for defendants to ensure that there is not too much liability laid at the feet of defendants who perhaps engaged in what otherwise is misleading conduct unwittingly. And that perhaps is one explanation of the statutory requirements around knowledge in cases of mere silence. So this complexity in the way in which the law regulates misleading conduct, misleading silence, needs to be taken into account in law reform and design. Now here, echoing again Commissioner Hayne, we think that this complexity highlights the great desirability of simplification projects in the statutory sphere, if indeed most of our statutory obligations can be removed down to 6 key principles. And if, as we've seen, the prohibition on misleading conduct has been replicated and reiterated in different forms in a way which undermines the power of the prohibition, then it seems very important that we should, try and get down to the nub of the problem. However, in doing that, we also need to be aware that some of the, for example, general law doctrines with which we're engaged serve multiple purposes. They touch a variety of different norms. They may be concerned both with misleading conduct and with relationships of trust and confidence. They may be concerned with vulnerabilities. They may be concerned with other forms of protections that need to be given in our society. So when, for example, designing disclosure obligations as part of a protective mechanism, we need to be very clear about what it is that we're trying to ameliorate, what we're trying to remedy as part of that design process. And I think that is the end of my slides. And my presentation.